Thank you for everybody who's come in, and for those who are going to join us later. We look forward to hosting. My name is Tabitha. I work with the lady to my left. I don't know whether I'm left or right on your screens. Penelope Munro. We both work at Thrings. I am a solicitor and I've worked with Penny. Is it 2 years now, P? Yeah, just over 2 years. And we thought that this would be a fantastic webinar, whatever your level. We've got partners, CEOs, but also trainees and paralegals joining us today. So I think in the conversations Penny and I have had, we just hope that you can take a little nugget of information away and focus the mind on making your clients love you if they don't already. There is, I think on your Zoom screens, a Q&A box, certainly at the bottom of my screen. If you have any questions, please pop them in there. We will be doing questions at the end, but we're picking them up sort of across the webinar, and we might not get to them all. I think Penny's going to speak for about 30 minutes. Then that should give us ample time to cover any questions that crop up. The webinar is being recorded, and slides or notes will be circulated afterwards by Bristol Law Society. And just for sort of some housekeeping, if you are interested in any other Bristol Law Society webinars, please email the events address or check out our BLS website, LinkedIn, those sorts of things. So that is, as I said, the housekeeping. I've introduced myself, and I will now pass you over to our speaker, Penny Munro, to talk you through, I think it's going to be a really brilliant webinar. So over to you, Penny.
Thanks very much, Tabby. I'm just going to share the screen. Hopefully you will now be able to minimise our faces. So hopefully you're getting the presentation in front of you. I mean, what I'm hoping for you to, as Tabby has already said, what I'm hoping for you to get a takeaway today is just some hints and tips on how to keep that client relationship and how to make it a better one. What we are looking ultimately is for these clients that you may take on for one transaction to be a repeat client of yours, even if you can't help them for their next transaction. Hopefully they will become your first port of call, therefore first port of call for you. So even if you can't help, you can transfer them to someone else in the team. As Tabby said, I am Penelope Munro. Other people call me P, Penny, Pepperty, Penfold, Penster, Lady P, you name it, I answer it. I'm actually also known by my own parents as Poppy because they have a black lab, and often I call home and they say, oh, Poppy, oh no, Penny. Anyway, I qualified in 2001 into the private client department, actually at Pardoe Solicitors in Somerset, after a zoology degree. I then did a senior status law degree at Bristol University, and then an LPC at the College of Law in York. As Tab said, I am now a senior associate at Thrings, very much specialist in wills and probate, but verging much more on sort of complex estates. There's our little team in Bath there, and unfortunately we have grown significantly during the pandemic. So note to self, we need to get some updated photographs done. How I'm hoping this webinar is going to help you. Well, existing client referrals, colleague referrals, and recommendation from my former clients are absolutely my best source of work. I have been to many dinner parties over the years, and the moment it is dropped into conversation that I'm a solicitor, my fellow guests instantly launch into horror stories about their dealings with lawyers. But what I've noticed that it is so few and far between that those guests will tell me about when their matters have gone beautifully. I don't want you to be another horror story. I'm just waiting for my next slide. There's a bit of an issue here. Right, how do we start that client relationship? Well, I'm very old school. I'll happily admit that. I treat my clients how I would want my own parents to be treated, with respect, kindness, and inclusivity. If my parents are paying for a service, they deserve absolutely the best client service they can get. In my case, many of my clients are similar ages to my parents, and if you can treat clients in this way with respect, kindness and inclusivity, hopefully you will not be adding to their worries, only helping to relieve them and taking some weight off their shoulders. Next slide, come on. One of my colleagues, one of my very senior colleagues, one of her favourite sayings is always assume that all assumptions are wrong. I mean, my own experience of getting it wrong was when I was a very young and naive trainee solicitor, and one of my clients emailed me to say that he had entered into a new relationship and he really ought to make provision for his partner in his will. When I emailed back, I asked how he might like to benefit her. Of course, his relationship was with a man, and I was taught a very strong lesson, which I have never forgotten. Never make assumptions. Equally, never assume shortening of names. One of my colleagues is Thomas, never Tom. He'll give you a very short, sharp shrift if you use Tom. It is one tiny thing that can make a huge difference and really upset your client if you get it wrong. As you will have noted from my introduction, I really don't give two hoots what you call me, but I'm not everyone. It is just a small, simple thing, but certainly one to take note of. Equally, when you're typing a name, just make sure you don't have autocorrect. If Clark is with an E, make sure you include the E. I mean, this is a simple one. Respect people's feelings, even if it doesn't mean anything to you. It could mean the absolute world to them. Make your clients feel that you are listening to them. You may be the only person they have spoken to in weeks, and they may get a lot of comfort offloading to you, particularly if you're dealing with a very, very stressful matter for them. Correspondence. Well, the bulk of my job is certainly emails and letters. Many of my clients are the older generation, so I let them lead on how they would like to be approached. I always start with formality. So in emails, I will always use Dear Mr. X, whatever his surname is, or Mrs. Bloggs, rather than Dear Richard or Dear Rachel. If I have been talking to the client and he or she has been calling me Penny, I'll follow up in my email, Dear Richard, if I may. The same goes for sending emails. The amount of times I have seen thanks from lawyers at the bottom of an email is too numerous to count. For what clients are paying, they absolutely deserve respect and formality, and that goes with my colleagues too. At the end of the day, the clients are paying you to do a job for them. I always end emails with yours sincerely, and if I like them, it'll always have kind regards before the yours sincerely. Next slide is waiting to come up. So what are the foundations of a successful client relationship? Well, I think they are genuinely honesty and consistency. Be honest about the current position on their matter and never be afraid to impart bad news. Bad news is often best told over the telephone or in person, but if you are imparting bad news and you can think of a solution on how to sort that problem out, tell them instantly after you've told the bad news. If clients trust you, they will open up to you, which ultimately leads to a better working relationship and will make your job easier. It is always better to know the background of your client to provide that tailored, bespoke service. Their reasons for not wanting to do something. What is their primary objective? What ultimately do they want? There may be other simpler ways of achieving their objectives which they haven't yet considered. To give you one of the examples from my own background, I was instructed by a very, very wealthy client to do some tax planning and prepare her will. And she wanted to leave everything to her niece in the States. And there was talk about transferring her house to her daughter, but paying market rent to live in there. Having actually been to see her with her financial advisor, she lived a very, very simple life. She lived in a beautiful thatched cottage, and all she really cared about were her horses and dogs. And we realised that actually making life complex for her was actually not ideal for her. And with the help of the financial advisor, what we actually did was insured her life with a life insurance policy and placed the policy out on trust. So for her, she really saw that we got to know who she was and what ultimately did she want. And we solved the issue in a very, very simple manner. Ultimately, communication with your client is absolutely key. Clients want to think they are your priority. They want to know that you are working for them and they are your number one, and you have their back, even if you do have 200 other clients. Now, how do we do this? We do that by keeping up the communication. The problem we have is that the problem we are up against is that clients will automatically assume that any problem or delay is your fault. And unless you take the time to explain the cause of any problem / delay, you are very much on a downward spiral. The best thing to do is to keep up the communication and tell the client, even if nothing has happened. Be proactive rather than reactive is so much better, and will make the client realise that you are acting for them. All clients really want to know is that you have their backs and that they are your number one, and you are still trying to push on that file, even if it is beyond your control. A brief update email or letter is the ideal opportunity to bring the position to date and enclose your latest invoice too. Last year, I actually wrote my client an incredible letter of gratitude for her unbelievable patience over the HM Revenue and Customs and Probate Registry delays. And when I sent her the latest invoice, in months of not hearing anything but me chasing on behind the scenes, she never chased me once, as she knew from my earlier treatment with my very quick responses to her emails, picking up the phone to her. She knew that I was working on her file, trying to move things along. And if you need to, use your diary to remind yourself to chase, or just to update clients saying, look, still waiting, HM Revenue and Customs haven't updated me, or the land registry, still huge delays. What you are ultimately trying to do is to inspire confidence in your clients that you are all over their matter and every base is covered. One of my clients recently texted me to tell me that a house upon which my estate had a charge on was selling that day. Now, unbeknown to her, I'd already been liaising with the solicitors about the day of completion and when my charge would be delayed, and giving over bank details. So I just texted back saying, yeah, all over it, they've got bank details. And she texted back saying, knew you'd be on it, which was just lovely. She knows I'm always on the ball with it. Hands up if you're wrong. I mean, if the delay or issue is your fault, hands up, hold your hands up and explain it to your clients, because ultimately, if you admit there's been a problem and it is your fault, they will respect you all the more for being quite so transparent. If you must, but your bosses won't appreciate it if you do, make this a habit, offer to discount your fees without them even asking if the problem is quite severe. Your clients will be very surprised with you saying actually it's your fault, but they will be very grateful. On the other hand, if the delay or problem is not your fault, make sure your clients know that it is not your fault. If you're anything like me, you'll have a guilty conscience, and perhaps I'm just a typical Brit, and assume that if I get an email that actually I can't check the file and there's a problem on it, I automatically assume, oh goodness, I must have done something wrong. But when I've actually checked the file, realised it's not actually my fault. So I've, gone back to them and said, yeah, no problem, that's probably a problem with probate registry, or, something's gone on, which isn't my fault. But if there is a problem, really all your clients want to know is that you can fix it. So give them a solution. Next slide. Here we are. If you're anything like me, your inbox is like the central line during the rush hour before the pandemic, constant emails flying in, many from clients, but many from team members and management. Organisation is absolutely the key to dealing. I'm one of those people who only has emails in my inbox which I need to deal with. Once replied to, I will file them away in separate client directories in Outlook. I try to reply to every email I get within a few hours of receipt during the day, the majority of whom I manage to send an immediate response. But if I can't do this because I need to investigate or make a phone call to investigate, whatever it is, I will send a brief email to say I've got your email, but I can't reply immediately, and to tell them when I'm going to give them a more substantive response. But I will give them an indication of timescale. And needless to say, that email remains in my inbox until I can reply properly. Don't be afraid, next slide, to pick up the phone. If you receive a call from a client, answer it. If you can't pick up the call for some reason, make sure you return the call as soon as you can. Don't make your clients chase you. Don't be afraid to pick up the phone and reply to a client's queries in person. It will save a whole ream of emails and sometimes the miscommunication which can happen with email. It can also lead to a build-up of rapport if you can have a general chit-chat at the same time. But if you do spend time talking about things other than the legal work, make sure you time record that element as business development. I once won a client for a lifetime supply simply because I took the time to ask him in one of our telephone conversations how his son was. His son had recently been diagnosed with leukemia and he was obviously rightly concerned. It is often the simplest things that build up a relationship with a client. Timescale. Next slide, wherever it's coming. Here we go. Clients want to know how long things are going to take. In my particular area, many clients have such unrealistic expectations of the estate being done and dusted within a few months. Now, this could be the case if we don't need to get a grant of probate, but in the vast majority of estates, it is going to take an awful lot longer. My job as their solicitor is to manage their expectations right at the start, to ensure that their hope on timescale and my experience of likely timescale are absolutely identical. Getting this right at the outset of a matter is absolutely paramount because it will only lead to the client becoming frustrated and lashing out at you if it is not. Giving a few minutes in your initial discussion to talk about likely timescale is worth its weight in gold in the long run. Tell your client why and what could delay the process. Talk about what is outside of your control in terms of timescale. Of course, if the matter goes and completes without a hitch and you thrash the initial estimate of timescale, the client is only going to love you more. But if the matter is one of those cursed ones where everything which can be delayed does, you will have at least managed expectations and the client will understand and realise it is not you delaying matters. Costs. You can't really have a meeting or a webinar on keeping clients happy without talking about costs. Ultimately, there are two reasons why you're employed. One, for you to earn a salary, and two, for you to make money for your firm. As you might have guessed, one of the top complaints of law firm is the costs were too high or higher than the quote, and they had not been updated. This is probably one of my favourite sayings. If you have to ask the price, you probably can't afford it. And it goes without saying that this saying does not apply in law firms. I've come up with a few brief rules on what I think we need to do in order to keep clients happy over costs, and we'll go through them now. Slide. Rule number one is be realistic over costs. If work is being done on an hourly rate, explain it to your client in person how this actually works. Even I think if I was quoted my own hourly rate, I would think it was expensive. But when I talk to clients about my hourly rate, I tell them very quickly that I can do an awful lot in an hour. Don't be afraid to own your hourly rate. You've certainly earned it, so take the time to justify it. Clients know the horror stories, and ultimately they are scared it's going to happen to them. As I say, the saying, if you have to ask the price, you probably can't afford it, must never apply in law firms. Clients want to know that they can afford you, and that is why you have to be realistic. Okay. Some prospective clients have tried to battle me down on quotes for wills, but I would much rather they come to me for an excellent service than for the cheapest price. I'll happily admit that we are unlikely to be the cheapest firm, but we will offer one of the best services. Have the confidence to know your worth and the service you offer to get the good paying clients rather than those who will whinge at every invoice you submit, even if it is within your quote. If you need to, talk the quote over with a colleague for a sense check. Most of my work is done on an hourly rate, so I normally give a band and explain in my letter of engagement that the wide band provides some flexibility should some aspects turn out to be more complex or time-consuming than initially anticipated. If something is complex in the matter, which is increasing your cost estimate, take the time to explain to your client why it is complex and the extra work required. I get many clients, prospective clients, phoning up and saying that they need a simple will, but upon delving under the surface, their will is far from simple, and it is our job to explain why and why the costs will therefore be higher. Explain to them how you can actually add value. Always ensure that your clients know what is included and excluded from your quote/estimate of costs, so your client has no nasty surprises when you bill them. You should be including disbursements, court fees. In my particular area, when I'm dealing with an estate, we specifically exclude the conveyancing costs. Your letter of engagement should make it absolutely crystal clear what is and what is not included in your costs. Rule number two, keep your client updated over costs at all times. Bills landing on your client's doormat should never be a surprise. We are absolutely duty bound to keep our clients updated on costs, and they are right to be angry if we don't. If you have agreed to only bill at the end of a matter, still keep the clients updated on the work in progress throughout. We don't want you getting to the end of the matter and suddenly realising you can't bill all of the WIP. The client would be absolutely right to be angry if you get to the end of the matter and suddenly try to update costs. He or she has a right to be updated throughout and be warned if the costs are likely to be higher. When you submit an interim bill, Make sure you review the cost estimate every time and consider whether you are still expecting to be within your cost estimate. Tell your clients if you are or if you're not. If you are expecting to have to increase cost estimate at some point, warn them that X, Y, and Z were more complex than initially anticipated. So whilst we are currently still within the cost estimate, you may need to increase costs at some point. So when you do tell them you have to increase costs at a later date, it won't be a complete shock, and they will be expecting it and understand. Equally, if you don't end up having to increase costs, the clients will be even more thrilled with you. It's all about managing expectations. Rule number 3, relish in your successes. If you finish a file within or under your initial cost estimate provided at the start, make a song and dance about it. It is really good news, so remind your clients of this when you write your final letter. Even if you have had to increase costs on a matter, it's not a complete disaster if your client can see that you have added value. For example, it's absolutely amazing that we've finished the matter, but it's a shame that HM Revenue and Customs asked so many questions about the inheritance tax account, but great news, we finally finished it. It doesn't take much, but just show them how you've added value. The trick really is to always leave your clients with a sweet taste. Rule number 4, transparency over bills. I'm one of these ones who always puts quite a long narrative in my bills. And includes how much I've spent on time and what the bill is. If you have agreed to discount your costs for some reason, make sure you include that discount in the bill narrative so your clients can see that you haven't forgotten to do this. Remind them you have done so in your covering letter. It is quite clear in my experience that clients would rather pay for an excellent service than save money and get a bad service. Why do I say this? Well, to give you a couple of examples, not long ago, I must have been absolutely half asleep when I quoted a really low figure to get the grant of probate, despite a full inheritance tax account being required to be completed and the copy will requiring to be proved because the original will had been stolen from the safe. In a burglary 6 months previously. No wonder the executors instantly instructed me. I duly sent the letter of engagement out, but when I wrote, I explained that whilst I had hugely underquoted, I would stick with that quote because it was my fault, but I would probably need to increase the cost estimate once the grant of probate came in, and if they wanted to go elsewhere, then they would be free to do so. The issue of the grant of probate is it's a pretty perfect break clause if you don't like your clients or they don't like you, and they can then go elsewhere. When the grant of probate duly issued, I emailed my clients to tell them that I would now be submitting my bill and reminding them about my underquote and updating costs for the post-grant work. To my absolute delight and surprise, however, they told me that they had been so happy with how I'd been dealing with the matter. They asked me to actually bill what was on the clock rather than my initial estimate. They also instructed me to finish the estate, so it was a bit of a win-win situation. Another example, just because you're increasing costs does not mean the breakdown of a relationship. I'm currently acting for 4 lovely daughters as executoresses of their late father's estate. Only 3 weeks ago, when billing it, when the latest bill had been included, I realised we were only about £2,500 off the upper estimate. And we've still got quite a lot of work to do. I mean, this estate is worth about 14 million. So, to put it into perspective, but it was amazing how we'd got up to costs or getting close to them. So whilst I was mortified, I wrote a very thorough email increasing costs by a further 7,500 to 10,500. So it was quite a significant increase, but I explained why. I was absolutely delighted, however, that every one of them emailed back straight away saying they didn't mind one bit because I'd held their hand every step of the way and I was worth every penny. They even took me out for lunch last week to thank me for everything I'm doing. It is worth mentioning here that if you ever do work for 4 daughters, take my advice and significantly increase that cost estimate to cover all those emails. What is my conclusion? I suppose my conclusion is this: if you know your worth and are confident of it, your clients will recognise your worth and be respectful of it. One of my colleagues actually sent me this saying, and I just thought it absolutely summed up what we should be doing as lawyers. Taking what we've sort of learned during this webinar, my best advice is to be open, honest, transparent and available, but also to try to get to know your client really well to be able to build up that rapport. You really want to finish that transaction with you being their first port of call in the event of a problem. Whilst you maybe not be able to help personally, for me, I don't touch conveyancing. It would be really risky of me to touch conveyancing, but I have some great colleagues who will do a really brilliant job for my clients. So I'm often called saying, oh, I need to sell my house. Penny, who can you recommend? And I'll instantly be able to transfer them to one of my colleagues. So hopefully, if you can't help personally, you'll be able to refer them to someone within your own firm or within your wider contacts. So your number for your client can be a really good one to have in their phone. Any questions?
Thank you, Penny. That was really good. It's as I said at the beginning, I think there's definitely some nuggets of information that we can take away there. A couple of questions came in on the Q&A chat, so if anyone does have any whilst we're going through, please pop them in the Q&A bit at the bottom. One of the first ones is basically, what are your top 3 tips to keep clients happy or to deal with clients?
I think I mentioned that I sort of droned on a bit during that webinar about being utterly open, honest and transparent and keeping that communication. If you keep up that communication, you respond to emails, you answer calls, you cannot go far wrong.
Yeah, no, I definitely agree, and it does make things easier in the long run. Another question, it's quite an interesting one actually, is around if you on a matter have failed to deliver or failed to meet a deadline, and the reason might be something with a colleague failing to deliver or failing to help you deliver ultimately to the client. How do you deal with that as the person who might be the one with the client relationship?
Well, if it's me who's done the problem, I'll absolutely hold my hands up and say, it's me, I'm really sorry. You know, I'm not Miss Perfect. I have had clients on the phone really, you know, going full blazes at me in the past. But if the problem has been my fault, I'll say, yeah, it's my fault. I'm really sorry. And it actually stops them dead in their tracks. If the problem is with a colleague, I suppose it depends. Your approach would very much depend on whether your colleague is an equal or a junior or more senior. Obviously, if a junior or equal, hopefully you'd be able to go up to that person and say, look, I asked you to do a piece of work. I haven't got it. Where is it? And, you know, perhaps open a dialogue. Is there anything wrong? You know, if you can't do it, let me know and I'll find someone else who can do it. If the problem is with somebody who is more senior to you, you might not feel comfortable putting your head against the pulpit because obviously you're concerned about your own careers and progressing within that firm, and you don't know how much power somebody has that's perhaps more senior to you. Yeah. My suggestion would then be to go to your supervisor to talk about the problem, and that supervisor can then decide how to deal with it. It could be that ultimately, if the colleague who's not delivering, if it's a regular occurrence, is there something that we need to get HR involved in? Is there a problem in their personal life? Is it something that HR needs to provide support? Ultimately, if they're failing to deliver because they're just not working hard enough or they're not getting the appropriate training to be able to do something, again, it needs to be looked at. Is it something that we need to raise a disciplinary procedure even? Yeah. But hopefully the person who's asked that person to do that work would would be mindful that they're waiting for that work and chase, you know, perhaps a few days before the deadline, and so that he or she can actually find someone else to do it if the work is beyond their capability.
Yeah, no, I definitely agree. And something we're quite good at between Penny and I at Thrings is, you know, and I think you said it, Penny, use your diary, put things in your diary, put it in their diary. So, you know, if you can put things in place to make sure things don't slip up or deadlines, you know, they're met rather than missed. And I think that really helps.
Absolutely. And equally, when you hand over a piece of work to the client, to your colleague, it's a really good thing to actually give them an indication of when you want it back by.
Yeah.
Because you're just gonna, you know, I remember as a trainee and a newly qualified, you just let things mount up in your desk, and you actually had to start prioritising matters. And that's part of the trick to being a solicitor, is really learning how to prioritise matters. I have a to-do list. I have a big A4 book, and I tick things off my list as I've done them. And it's all about managing your time effectively. And my to-do list changes every day. I write a new to-do list, and some things go across to a couple of days, a week maybe, before I actually get down to do it, because I'm constantly bombarded with other stuff, especially now as I'm a little bit more senior. I get management of staff as well. But yeah, I mean, certainly when giving the matter to your colleagues, particularly if it's a junior, you know, are you happy to do this? Do you want to have a chat about what I actually need before you go ahead, or do you want to go and have a thrash at it and get it back to me by 5 o'clock tomorrow night, and then we can have a sit down? So I think it is a two-way thing when you are asking colleagues to help. But don't be afraid to ask questions or speak to your supervisor about it. Yeah. Great question.
This is I quite like this question, and I'm not a client partner, but I've definitely got clients that might be my own, and it's sort of, if you're a client partner or you look after a client, and you don't have any active matters with that client, either yourself or on the firm, how do you maintain that good relationship with the client where there's no instruction at present, but you know, you're their first port of call, like you said in your speech then?
Well, I would pick up the phone. I might offer to take them out for coffee. Bath and Bristol have some fabulous coffee shops. There's nothing, and we do have a budget at Thrings here for business development. It may not lead to any work then, but it might lead to work in the future. Picking up the phone once a year, that's not going to be, you know, certainly at Thrings, we've had during the pandemic a very much a focus on what clients we need or want from us. And I think that's been a really good focus for our clients, on making sure that their needs are met in certainly these huge changing circumstances. But a cup of coffee, you know, even if it's you don't have the budget at work, you know, it's 5 or 6 quid, and hopefully you'll have a really nice coffee chat.
Yeah, no, an interesting one is obviously quite topical, is how will making your clients love you and your hourly rate be impacted when we start going back to the office, when we start going back to work? Do you think it will be impacted when we're back in the office?
Well, 90% of my clients haven't really seen a huge difference in the way I work, because I have still managed to have, you know, I have, with us will solicitors, we have been allocated as key workers, if you like. So I have had a few meetings with clients in the gardens or outside the front of their house to execute wills. But clearly we have gone a lot more to video meetings, which for me works really, really well. I've got really used to them now. And actually, in some ways, clients actually prefer it because they're sitting in their own sitting room and feeling very comfortable in their surroundings. So in future, I will certainly offer the video meetings if it's appropriate. I mean, the little old 95-year-old woman who perhaps wants to do a power of attorney or update her will might not be most appropriate, because she may not be used to FaceTime or WhatsApp video or Zoom or Microsoft Teams. But certainly it's something that we will continue to offer. I suppose offering video meetings from the office will be a bit more of a challenge, because you'll be booking a whole room out just to sit there on your own in front of your phone or laptop. I think the firms are probably going to have to start getting video conferencing facilities in every room, in every meeting room, because obviously, I mean, certainly in Bath, Tabby and I work in a very much an open plan office, so it can get quite noisy when it is full to capacity.
Yeah.
But certainly my clients haven't really seen a huge difference, because we have a fabulous team that are scanning in all the posts to us. And we are going to maintain a bit of flexibility at Thrings. It all depends on the teams, but some of us, we're going to be working 3 days a week in the office, so we've still got some flexibility. But equally, if I have a video meeting, which I know is going to be a challenge for any reason, whether it's a meeting with 4 executors, I may still decide to do that at home, because I know I can trust my Wi-Fi at home.
Yeah, and I think another thing is with going back to the office, like you said, the service hopefully hasn't changed, but we now know that we can do video calls with clients, and we can, like you said in your presentation, let the clients leave. They might prefer, you know, we can still ask them, do you want a video call?
Yeah.
Or actually, now we're in the office, we can do face-to-face, or
Yeah.
so hopefully it will.
Things have opened up for clients. It's lovely, really, now that we can offer this extra string to our bows.
Exactly that. Another question that's come in is, do emails need to be as formal as a letter? Also, you know, like a written letter that goes out in the post?
Well, I mean, it certainly, if it's a change to your letter of engagement terms of business, our letter of engagement says we will update you in writing if we're going to update costs, increase our cost estimate. So I would always send that by letter. The majority of our stuff does go by email, but in response to that question, I would always still be guided by formality. I'm one of these ones that when I qualified in 2001, so quite a long time ago now, but back in 2001, we didn't have emails, and so we were dealing only with phone calls and letters in, letters out, and the occasional fax. So things weren't so quick as things were. Really, what your work depended on what the post was that came in that day. So but the moment you'd seen the post at 9 o'clock in the morning, you knew exactly what your plans were for the day, subject to odd clients popping in or meetings. Obviously with emails, yes, absolutely, you should always use dear Mr. and Mrs. or dear Mr. until they respond saying dear Penny. Keep up that formality absolutely throughout, and if they continue to call you dear Mrs. Munro, or you keep up that dear Mr. until they say, oh, please call me Jack. It's just one of these things. And, you know, rather than saying thanks at the bottom, I've seen it too many times, put yours sincerely. Or if you're writing to a firm of solicitors, it's dear sirs, yours faithfully. It just to retain that element of formality, rather than automatically calling them by that first name, goes a very long way to starting that client relationship. I mean, 90% of my clients, we all turn to first names within a few emails. But I absolutely am guided by the client in that one. So yes, absolutely, emails should be as formal as letters.
Yeah, and I think we all write differently. So your personality will still, even though you've got, you know, our approach is definitely formality, you can still come across as you, as the solicitor, as the Penny, as the Tabitha in your correspondence. But it's that respect thing that I think Penny said, you know, you don't want to be seen as the sloppy solicitor or the solicitor that comes up at the dinner party. You can save that for the weekends.
Absolutely.
I think another question that I think is we'll sometimes have clients who are like this, and it says how to avoid clients. This was in relation to a conveyancer, but I think generally solicitors, how do we avoid it? Clients constantly emailing daily and expecting things to be turned around or progressed immediately after they've spoken to you, or, you know, emailed them. How do we manage that? How do we?
I think this is actually something to be brought up in your initial meeting or telephone call with clients. I will say to clients that I'm happy for you to email me for an update at any time, but the way I tend to work is that I will let you know when there's an update. And because of the way I work, I update my clients very regularly. So spend a few minutes, why the costs are not such simple costs as they'd thought. At the same time, you give your estimate of likely timescale, so that your estimates of timescale and their hope for timescale are absolutely identical. Talk to them about emails and say, look, an email chasing me, you can be utterly blunt and transparent, because they'll respect you all the more for it, and say, look, I'm really happy to update you as often as you like, but I've given you an estimate based on this. If you're emailing me every day or phoning me every day, I'm going to have to increase that at some point, those costs. And, you know, you're absolutely right to ask for an update, but I will update you regularly. I once had a client who phoned me up. I was dealing with his late mother's estate. There were shares and bank accounts absolutely everywhere. And every day he would phone me up at 5 o'clock for an update. And I actually said to him, you know, I really do love speaking to you. And I actually said, I love speaking to you, but you have to understand that every time I speak to you, and we've spoken 4 nights this week, I'm speaking to you for 18 minutes, you know, 3 units of time each time I speak. And it is going to have a horrendous knock-on effect to the estate administration. He stopped calling. And instead I just updated him once a week with the updated schedule of assets and liabilities and what the movements that week. It's all about getting your clients to understand how you work, but also you inspiring confidence to them about how best to manage your matter.
Yeah.
You're the expert here. That's what they're paying you for.
Yeah, we just had another question come in on the chat function, and it says, is there anything wrong with an automatic email response, acknowledging receipt of it, and then giving an expectation of response time?
Well, actually, I have one on my, currently on now. I have an automatic response going on now because I knew I was going to be preparing for this webinar, and I'm off tomorrow and on Friday on holiday. So I have an email really managing clients' expectations that gets that. I certainly do not have that on all the time. I think if you've got a week of heavy meetings that you know that your actual timescale, your actual legal work where you're going to be able to get down to it is limited, then it would be sensible saying I'm in meetings this week, but I will try and respond to you in between meetings, but I cannot give a guarantee of, I can't actually give a guarantee of when that's going to be, but I wouldn't have it on all the time.
Yeah, yeah. An interesting question that's actually just come in on the chat, but it says, how do you deal with clients who ultimately ignore your advice? It's like watching someone about to have a car crash, but you can't stop it.
Yeah, I think most of us have had clients like this in the past. All you can do is write an extremely thorough letter setting out the pros and cons of them ignoring your advice. If they are still proceeding on that path, I would strongly recommend that you get them to sign a letter saying that you have given them advice not to follow that path, but they have decided to ignore it. I had one recently, only 18 months ago, where somebody died intestate, leaving a husband and son. And the estate just simply wasn't going to be divided under the intestacy rules as the clients wanted it, as the son and husband wanted it. So we entered into a deed of variation, and when I sent it out to them, I said, you really both need independent legal advice, because I didn't, it worked perfectly for the circumstances, but I thought there were pros and cons for each of them, and I wanted them to know it. And they refused to take my advice and get that independent legal advice. So I got them to sign a letter saying they've had the advice from me and Thrings to get independent legal advice, but they have decided to go against that advice. And as long as you've got them, you've told them that this is a disaster, this is a potential car crash, it's only going to go one way. Is that effectively an indemnity? No, I don't think it is, actually. I think it's basically you telling them that you've given them the advice and they're ignoring it, and you cannot be held responsible for X, Y, and Z going wrong.
And I think also, like you were saying earlier, you know, if you've got, you know, you believe in your hourly rate, believe in yourself there. If you are confident, or, you know, and you know that you've given the advice that you need to give, and they're not going to take it, you're not going to necessarily change that sort of person. And sort of similarly, you can't please all the people all the time. Sometimes there are going to be clients that don't listen to you, or clients that don't take your advice. And I think, as Penny said, if you believe in yourself and you do all the things that we've talked about, I think it can be easier to take a step back and say, this is the car crash, but I know that I'm not the cause of the car crash. And they, you know, we're all free to make up our own minds.
Yeah, absolutely. Ultimately, they are coming for you for advice. You tell them the options available. And if you tell, you know, for each option, normally one would give why and why not. And then at the bottom, you say, well, ultimately, it's your decision. Ultimately, it's your decision whether to take my advice or not. I look forward to hearing from you once you've made your decision. But yeah, you can't force someone to go down a path.
No, you can't. I think I'll do maybe one more question. We've got about 5 minutes.
There's quite an interesting one. Do I ever turn clients away?
Oh yeah, that's a good one.
No, I don't. But I will not stand for someone who's trying to battle my hourly rate down or my cost estimate. So no, I don't. I certainly, at my previous firm, we had a bad, you know, if clients didn't pay their bills, they would be known as a bad debtor. And if they came through and as a bad debtor when we opened the file, we would ask them for a money on account for the work they wanted.
Yeah, it's just a tricky one. I think people, yeah, like you say, you can't stand for certain types of clients if you know that they've got a history of that.
Yeah.
And the last question I was actually going to pick up on was, I mean, maybe you sort of touched it, that how do we address hourly rate increases? How do you deal with that with the client that maybe you have an ongoing instruction with, versus maybe a new client?
It's a change ultimately to your letter of engagement. So you need to be telling them of any hourly rate formally in writing. And certainly our letter of engagement tells clients in the letter of engagement, which they sign and return, whether that's by electronic means or physically to us. And it says our hourly rates will be reviewed every year. So if you do have an hourly rate increase, then, well, they've already signed up that they've accepted that by signing the letter of engagement. Certainly, if you are nearly at the end of the matter and your hourly rate goes up, it's probably not worth increasing your hourly rate. Certainly at Thrings, we have discretion whether to increase hourly rates for clients. You know, some of mine, I haven't gone up to the hourly rate. I haven't upped the hourly rate on our recent increases, but some I have, because I know we're going to be going on a long way. Certainly, it's you've deserved that hourly rate increase. You're another year's qualified. You've had another year of experience under your belt. So you deserve that hourly rate increase. So never feel bad about it. But remember, when you are telling them about the hourly rate increase, think about whether it's going to increase your cost estimate.
Absolutely.
Because for every hour, you're going to have, whether it's 10, 20, 30 pounds an hour added on. So certainly don't ever be afraid of telling your client that your hourly rate's going up. Certainly my hairdresser's gone up. They now charge me £20 for a hair to blow dry it after it's been coloured. But yeah, so if everybody else is going up, why shouldn't our costs go up?
That's a good point. I think that's a good anecdote to end on there. So as I said at the beginning, the slides and notes will be circulated at the end. Thank you everybody for joining us. I think you've got maybe 2 minutes to go and grab a bite to eat before you'll get back to our desks. And this is being recorded, so if you want to share any of Penny's wisdom with your colleagues, then it will be on the BLS sort of website. So thank you.
Yeah, equally,
everybody.
if anyone's got any burning questions following the webinar, I'd be happy to answer them. Just send an email to Bristol Law Society if there are any questions that we haven't been able to answer. Thanks, Tabby.
Bye.